Arbitration is a method of resolving disputes, not only contributing to issues being resolved faster, but also to bring about economic development of a country. However, solicitors arbitrators in the 2022 International Arbitration Conference have gathered together to find ways of resolving disputes amongst the clients both at the bar and the bench, with the theme Recent Trends and Opportunities in International Commercial Arbitration. Speaking at the International Law Conference, the guest speaker of the day, a senior advocate of Nigeria and the past chairman of the association, Adedoyin Rose-Vivo, in a speech stated that when parties enter into a relationship, they must indicate an arbitration clause in their contract, as she had a view on what the government and the arbitrator solicitors ought to put in order not to congest the court system.
I would like the government to be arbitration-centric, which they are to a large extent in Nigerian courts, but there's still a lot more to be done. And for the new Arbitration Act to be passed, so that Nigeria can be considered as one of the countries that have very modern arbitration laws. I'd like us to be security conscious for economic prosperity and development. I know many countries right now are facing security challenges. To be security conscious so that people and investors will not be wary about coming to Nigeria or investing in Nigeria. That's one of the things. And I'd like our courts to also be more time conscious. The courts are suffering a lot of challenges, not basically only because of the courts, but because, as even the Chief Justice of Nigeria said, Nigerians are very litigious. They like to go to court for everything, without thinking of the repercussions on the dockets of the judges, on the perception of the country. So I'd like us to have more effective ways of resolving our disputes outside the court system and stop congesting the courts.
Speaking further to KAFTAN television, the newly inducted chairman of the association, Tolu Aderemi, also aired his view on the day.
For the first time, arbitrators have come together, or we are coming together, to identify what our problems are, particularly as it relates to our clients, the users of arbitration. And we have identified two of them as key: delay in the cost of justice administration and the inefficient time that we have infused into the practice of arbitration. So it's almost defeating the essence of quick dispensation of justice. So we have identified those two problems, and we've spent time to unpack them and profile solutions, not only on how we're going to attend to them, but pragmatic steps of how we're going to be dealing with them.
The arbitrator solicitors encourage lawyers to enter into agreement not only through arbitration, as there are other alternative ways such as mediation method, considering method, dispute review board, and many more, rather than looking at the court system as the only way of resolving issues, thereby congesting the courts.